And this time we are going to talk about ILR, which is
Yes.
one of the hot topics. So there are a lot of things which government has not announced, but there are a lot of changes which are happening. Now what's happening? People are still applying for ILR, which is
Yes.
they're getting it in 5 years. Who is eligible for as of now? Like,
Okay.
can you talk about
Yes.
the timeline here?
Absolutely.
How aware are people about this 28 days timeline? How it used to be handled before and how they are doing it now.
Yes.
Yeah.
That's a good thing.
Yeah. Now, if someone is going to do a new application now,
For settlement.
for settlement, what suggestions would you give them?
Okay.
Hi guys, welcome back to another episode of The Hat Man. And since our maybe 10th or 15th episode,
That's right.
we've been getting a lot of really good inquiries and questions
Absolutely.
from people, and I think our viewership is going up.
Absolutely.
People have been watching and then they've been commenting. That's really good. Positive or negative, everything is good.
Yes, of
Yeah.
course.
Any
Any criticism, we will take it in a constructive way.
So any criticism is constructive
Absolutely.
criticism. Okay, so guys, welcome back, and this time we are going to talk about ILR, which is
Yes.
one of the hot topics. So there are a lot of things which government has not announced, but there are a lot of changes which are happening.
Yes, in the
background.
process.
In the process, at the background. And once you start the process, only then you realize that there are changes
Absolutely.
happening, right? So we are going to discuss about that, like what these
Yeah.
changes are and where they have made some amendments as well.
That's right.
So guys, please watch the whole video because it's very informative. It is going to be very informative because there are a lot of changes which are happening, and if you know about those changes, when you apply for ILR, you can be really cautious and you can take those measures.
Absolutely.
Is it
And
right?
it will help you to get decision quicker
Yeah.
and also a positive decision.
Positive decision. So before we get into this episode, a lot of people have been watching us without subscribing. So we have around 60 to 70% not subscribed to us. So please do subscribe so that we can create more interesting content and maybe more interesting content and also like more informative content. So please do subscribe and watch. And let's go into the topic
Absolutely.
now. So let's start with the introduction. If someone is new, I want to introduce Mr. Badri Bala Venkateshan, who is a senior immigration consultant and
Lawyer.
a lawyer. And his company is called Universal Fortune Limited, which is www.ufvisas.com.
Correct.
If you want to go and contact him or his team, you have all his contacts on that website.
Yes.
Okay. He has around 6,000 plus happy customers. And you might have heard of IAA. So they've done level 3 of IAA, which means that he can represent you in any court as far as the case is
For immigration.
for
purpose.
immigration purpose only.
Yeah.
Okay, so let's get into the topic now.
Absolutely.
So ILR is has been very hot topic. Settlement,
Yes.
which has been a very hot topic for last couple of years now.
Absolutely.
Since the announcement and changes to the
Yes.
announcement. Now what's happening? People are still applying for ILR, which is
Yes.
they're getting it in 5 years.
Yes.
Yeah.
So let's go for a short recap.
Yeah.
What happened since the white paper was announced in May 2025. What they proposed is that they are going to increase for skilled worker from RQF 3 to RQF 6, which they have done. And they said they are going to increase the English level from B1 to B2 for skilled worker, which they have done from 8 January 2026. And they also said that they're going to increase for settlement the English requirement from B1 to B2, which is going to happen, which has already been announced, that will come in effect from March 2027. The other bits which has been proposed but it's not yet implemented, still at the consultation stage, which is retrospectively they want to increase the settlement timeline from 5 to 10 years to everyone, and they said make your way down, and they gave certain points where you can get discounts for the number of years you can reduce from 10 years to 5 years, or even you can get settlement for high earners, even you can get settlement in 3 years.
That's called earned citizenship.
And settlement, yes.
Yeah.
And initially they proposed it will come in effect from spring 2026, which was luckily moved to autumn 26. Again, it's all still at the consultation stage. Nothing has come as a law. And during the consultation, almost 130,000 people, not at consultation stage because we have passed the consultation stage. I should say it is at the kind of conclusion stage where they are going to give a report of the outcome of the consultation. They received around 130k, which we are expecting probably before August or September. I mean, what is the response from the consultation? And then autumn, anything between September to October, which they said it can come in effect. However, this can get delayed, or this may not even come, or this may come. That's how it is.
You never know.
You never know. As of now, it has not been as a law. Whatever is the rule currently in place, that is what we are going to talk about. This is just a recap. So my suggestion is anyone who is or eligible for settlement, you should not delay. It may come in autumn or it may not even come, but if you are eligible, you should not delay.
Okay. So talking about the eligibility, let's go back and just have a recap on that. Who is eligible for as of now? Like,
okay.
Can you talk about
Yes,
the timelines? Yeah.
Absolutely. So currently, if you're asking a question who are eligible, let's start with skilled worker visa. If you are on skilled worker visa and if you have completed 5 years as per the current rules which is in place, you can apply for settlement 28 days before completion of 5 years. And there is another criteria which is long residency, and that's based on 10 years.
That's for the students and everyone.
And you can combine even your student period, you can even combine your work permit, graduate visa, which is post-study work, which is also known as post-study work, or any dependent visa. You can combine any legal stay, and which is over 6 months, any legal stay, you can take it, and you can combine that 10 years. Again, before 28 days completion, you can apply for the settlement. And there is also global talent visa, which you can get your settlement in 3 years. Also that applies to innovator founder visa. So these are the main 3 categories: 3 years, 5 years and 10 years. Now for all of this route, common thing is you need to pass life in the UK test.
So before we go there, like from your experience, how aware are people about this 28 days timeline?
I think most of them are aware.
Okay.
I would say 90% of them are aware of it, that they can apply 28 days before of either completing 10 years or 5 years.
Okay.
But people, they used to be, for instance, they have they have 6 years visa, though they have completed 5 years. People used to be like, okay, let's apply towards 6th year.
Yeah.
That is what is not acceptable now.
Yeah.
I wouldn't say it's not acceptable, it is still acceptable, but it is not recommended.
Yeah.
So
okay,
sooner the better. Now for all of this, so which are the categories I've told you, you need to pass life in the UK test and English level, which is currently at B1. Now let's focus on skilled worker visa only, because that is what people are applying. Most of them, the big number of people who are coming to settlement is from this category. So we will talk about that. Now there is a lot of changes has happened in the last month or two.
Yeah.
How Home Office is processing the ILR applications.
So when you say changes, it's not announced changes?
No. There is no change in immigration rules.
Yes.
Please understand.
Yeah.
There is no change in immigration rules. I'm only talking about the way Home Office is handling
the cases.
the cases.
Okay.
What are the changes is happening? What are the additional information they are asking, which they never used to ask?
Okay.
But these things are changing now.
Okay.
So we are going to only talk about those changes and process, what has changed, what people should be aware of.
Can we do this way? Can you take an example before and after?
Yeah.
How it used to be handled before, and how they are doing it now.
Yes.
Yeah.
That's a good thing.
Yeah.
So let's say if someone is on skilled worker visa, how it used to be before, most of the cases, I would say 95% plus of cases, what happens is Home Office would ask for the letter from the employer which confirms the position is still ongoing and there is no change in any foreseeable future, and recent 1 month pay slip and recent bank statement, and if that reflects on the going rate, that should be enough. And they would apply, they would grant the settlement, and this is the same thing. Even now it applies the same. However, what is happening is these days what we see, when you apply for previously for super priority, you get in same day, or when you apply for priority, you get it in a week sooner. But now it is still they are doing in 1 day super priority and priority in 5 days. However, the number of applications, I would say almost 40 to 50% of the applications they are holding. They are doing more checks and they are granting after 10 days. They are granting after 3 weeks. They are granting after 2 months as well.
Okay.
I would say this is happening especially after April. Now, why are they
Delaying?
Why are they delaying? What is taking them more time? Mostly they are doing checks with HMRC. And in May 11 to 2026, Home Office caseworking guidance has changed, and they have added this point. I would like to bring it to your notice. This is in page number 58 in published for Home Office staff. And this guidance was updated on 11th May 2026. To be precise, it's page number 60 and 61. So what Home Office guidance which they have updated is, you must consider the salary in the same way as set out in the assessing salary section of this guidance. You can only consider the salary for the 48 hours a week towards the general salary threshold. You can only include the salary from the applicant sponsored job. You cannot include the earnings from supplementary employment. For instance, if the requirement for someone is let's say who is on RQF level 3, 31,300, they cannot combine a salary which they are receiving along with the supplementary job. It should be from the main job. That is what they are saying. This has been before, but I'm just reading out the changes which they have brought. I'm going to talk about it now. You should check the applicant's PAYE records for the past 12 months. This has never been before. This is something they have started.
Something which is introduced now.
Until automated PAYE checks are available, applicants should provide a pay slip, either a bank statement or building society statement, covering their most recent month pay with their application. The document should be dated no earlier than 31 days before the date of the application. So what they are trying to say is that Home Office should check for 12 months of their salary. They have also added one more point. You do not need to check their records for the past 12 months if you do not have concerns. Okay. So what they are saying is, if these do not support the minimum salary, the sponsor states that applicant will be paid for the foreseeable future. You should discuss the case with the manager and consider requesting further information from the sponsor about why they claim the applicant will be paid more now and in future. You will need to assess the credibility of such claims on the balance of probabilities, with relevant factors includes the size of any pay increase, whether the applicant has already been paid the increase and for how long, evidence of the applicant has been offered a promotion and increased responsibility, evidence the sponsor business can support the salary increase. So lot of people are increasing the salary just 3 months before going for indefinite leave to remain, 6 months before going to indefinite leave to remain. It is nothing wrong in that. But if they see there has been sudden change and they are asking, first get the 12 months bank statement. And also ask these questions, whether the business can afford the salary increase, can support the salary increase, and what evidence they have that for the salary increase. For example, if there is promotion, get the evidence of those documents and everything. So this is what is happening these days. Home Office is holding the application, and who we have seen, it's not, I won't say whoever, but we are seeing this pattern increase in number of applications. Whoever salary been increased in 3 months or 6 months, they are asking for the last 12 months. And after providing it, they are asking some of the evidences, and once we provide, they are still granting it. However, this is a new thing which I have seen in the last 1 month. We came across a case where the applicant applied for settlement. They held the application and they went for a compliance check to the company. And they did a thorough compliance check. They interviewed not only this staff, along with this staff, they also interviewed 2 other staffs who are working.
Why would they do that, compliance?
Home Office, if they have any concerns, they have right to do it. So we do not know.
So not only in this particular example, not only the employee, even the employer was checked.
Yes. Employer was interviewed. Mostly it was employee it was for the sponsor. It was for the company. A part of the compliance check, 75% most of the questions and most of the time they will be spending with the employer, and 25% time, or I would say they would be spending less time, and they do still interview the employee, whoever employed there, I mean under the sponsorship. So
the first case was 75% is for the employee, and then this
employer,
is employee, and this is employer 25%.
No. 75% for the employer.
The guy who's given the job, employer.
And 25% for the employee.
So the whole
when the compliance check happens.
When the compliance.
Only when the compliance check. Okay. So this is one of the scenarios.
So before you go to the next point, you spoke about something called a supplementary
supplementary
jobs. So what happens is you are allowed to do a 20 hours.
Up to 20 hours in any eligible occupation
list. So they are saying that you cannot add that salary.
Towards and you cannot bring that saying that I'm meeting the salary requirement.
So was it allowed before?
No, never.
Never. Okay, fine.
But they have. That's what I'm just
reading. Clearly,
I was reading the full section, so it was there.
Oh, fine. Okay.
So this is a new pattern which they have started, and this is one of the cases, and. Everything, luckily the compliance check with the company went well. So the applicant is still waiting for the outcome, but we are sure it will be successful. And there is another case where the applicant applied for settlement. The application was held and they sent an email asking company 9 list of documents, which I am going to tell you what they have asked. And they said, if you do not provide those documents, we will directly revoke your license. So, which means if they are revoking the license, that means the person who has applied for settlement can be refused. His settlement can be refused. So, this is something they have started holding the application. If you ask, is it happening for every application? No. I would say probably 40 to 50% of the applications it's happening. And where, for instance, they have increased the salary recently. The reason why they are asking 12 months is pay slips and bank statement to see whether they are receiving the exact salary as per the certificate of sponsorship, and whether the increase is genuine, not for the purpose of ILR. And also if the salary is not paid in the bank transfer, they can simply suspend or revoke the license. And based on this, they can also refuse the settlement application. So this is something people should be aware of it, and you have to speak to your employer and make sure they follow the sponsorship duties.
Yeah.
The next video what we're going to talk about is purely for employers. What steps they have to take for compliance check.
Yeah.
What are the things they have to be aware of it, and this way how they can protect the license and the workers.
Yeah.
So anyone going for extension or settlement. So that is what we are going to talk about.
Okay, fine.
Okay.
Fine.
But in this video, we are talking about what are the process has been changed by the Home Office.
Yeah, yeah.
And most importantly,
So now you said this, sorry to cut you that. So the other question which I have right now is, you mentioned that these are the things which is happening. They've changed the way they are handling the applications.
correct,
Now, if someone is going to do a new application now,
for settlement.
For settlement, what suggestions would you give them?
Okay. So if someone is going for settlement, the first thing is, a lot of people I come across when they come for the initial consultation, I would say 40% of them, they are not aware of the current going rate. So the current going rate says, it's if your position is under RQF 3 or 6, because you come under the transitional arrangement, most of them, whoever is coming for settlement now, they would have got their visa before 4th April 2024. So it should be at least at 31,300 or going rate, whichever is higher. So for instance, if someone is going for settlement and as a fuel station manager, the going rate requirement is 31,300. But when they got their extension, 26K, 27K was enough. I came across a lot of people, they are getting paid as 27K. So now they will not be eligible for settlement until or unless if the employer is happy to increase, and they have to justify why they are increasing, not for the purpose of settlement, but they are increasing because based on his performance, and they want to keep him longer, whatever valid reason is there, then it will be acceptable by the Home Office. So the first thing is, before coming to the settlement, you have to see what is the going rate for your position and make sure your salary is in the line, and you need to speak to your employer if they are willing to do the pay increase, if they can do a performance review on your employment, and if they can increase it. This is what you have to ask. I want a salary increase. You can ask. It is always there is it's not illegal. You can ask your employer, and you can ask them to do a performance review, and if they are happy and they can justify your performance good and they are increasing to going rate, that will be the first thing. So
I have a question. If someone is going to apply for his ILR next week, so he is just after seeing our video, he found out that his salary is only 29,000, going rate is 31 or something. So now if he gets goes to his employer, gets his salary hiked, can he still apply within a week and get the ILR?
No.
Oh.
You need to complete 1 month and show your recent salary and bank statement showing that hike, and then you can go. However, Home Office can still, there is a high possibility they won't refuse. They can hold the application, and they can ask for the last 12 months, and if it has been increased only a month before, they can always ask for the documents, which we just saw. Which we saw just now and which we read. So people have to make sure, and everything has to be genuine. You cannot provide any false information to the Home Office.
Okay, the other thing is, like you said that you'll show the set of documents. Sorry, I asked you a question and we slipped.
Yes.
But we'll put it somewhere in the
video. What are the normal set of documents are required?
We'll put it on the video, and it'll be on the description as well.
In the description.
The second point, like because a lot of people, they don't go through a lawyer. They fill their own form and then they go.
Question.
Yeah. They make a mistake because when they go applied it, without knowing they put 29,000, they've applied it.
Correct.
Now, obviously it will be rejected.
Absolutely refused.
Okay, it will be refused. Then afterwards, like what happens to that application?
As long as if they are having visa, they can correct the points which Home Office has raised, and as long as they have not provided any false documentation or used deception, they can reapply, correcting those errors.
And is there a time period?
I mean, they can apply anytime before their visa expires, skilled worker visa expires.
So you said that there was a really good point which you mentioned. As long as they have a valid visa.
Correct.
If they are towards the end of a visa they're doing, then it's a problem for them. Okay.
Yes.
So, but like instantly, if for example Monday they applied, Wednesday it was rejected, Thursday itself they can reapply?
No.
No.
You have to correct
and
those,
then and
correct
do
those
a 1
errors,
month
and then you have to.
then
But
it's
we
a
need
big
to
risk.
see the reason. What is the reason for refusal?
No, I'll tell you the reason is
for
the salary.
Then you need to wait for a month. And you have to show there has been genuinely your salary.
That's
has
a big
been
risk,
increased.
right?
Exactly.
Okay, fine. So
not for the sake of ILR. It should be genuinely Home Office can ask why this salary increase. How can you justify this? So they need to provide all those.
And that's when they go to the employer as well and they check whether they can do it or not.
Correct.
Okay. And are there, so this I don't know, you shouldn't mention this. Are there cases where like the employers just strike it for the sake of PR and they revoke it, they go back to the old salary?
No, that is if they are doing that is illegal.
Maybe that's the reason they're checking it. You never know.
No, exactly. That is something, if they are doing for the sake of thing, that is why Home Office has taken the steps to
extra
check.
steps to check. Yeah, okay.
Exactly. So that is something is not legal.
Then they might have done it. Yes. Someone would have done it for them to check it.
Yes.
To put that extra checking, right?
Exactly.
Yeah, okay, fine.
Yeah.
All right. So is there anything to cover in this?
That's it really. Yeah. So all I want to say is the conclusion is if you are eligible, do it as soon as possible and always go through a regulated IAA immigration consultant or lawyer or a solicitor who are regulated by SRA.
Yeah.
Please do not go to unregulated agents or people. They might charge a few £100. They might say that you will be saving so much money, but they do not have enough knowledge, and when they do something wrong you cannot hold them responsible. And not only that, when they do the application they do as you are doing, they do not put their name. So whatever information provided, you will be
penalized
for that. You cannot say I've given to this guy and he did it. So always go through a regulated person. And again, finally, I want to say this full video is purely for information purpose, and they should not be taken as immigration advice. If you need any immigration advice, we need to see your case on individual basis, and again you should go to a qualified person.
Thank you. We'll meet in the next episode.
Absolutely.
Thank you.
Cheers.